3, 2, 1, start. The present appeal has been preferred by the insurance company against the award passed by the Motor Accident Claims Tribunal, whereby compensation was granted to the claimants on account of the death of the deceased in a road accident. The appellant has challenged both the finding regarding liability and the amount of compensation awarded by the tribunal. According to the claim petition, the deceased was travelling on a motorcycle when a vehicle coming from the opposite direction struck the motorcycle near a public crossing. It was alleged that the offending vehicle was being driven at excessive speed and without proper care. As a result of the collision, the deceased sustained serious injuries and was immediately taken to a nearby hospital where he subsequently died during treatment. The claimants, being dependent upon his income, sought compensation from the driver, owner, and insurer of the offending vehicle. The driver and owner denied negligence and asserted that the accident occurred because the deceased suddenly entered the main road without observing traffic. The insurance company also contested the claim and pleaded that the driver did not possess a valid driving license on the date of the accident. It was therefore submitted that there had been a breach of the terms and conditions of the insurance policy. After considering the oral and documentary evidence, the tribunal concluded that the accident had occurred due to the negligent driving of the offending vehicle. While determining compensation, the tribunal considered the age, income, occupation, and number of dependents of the deceased. Appropriate amount were also granted towards loss of dependency, funeral expenses, loss of estate, and other permissible heads. Learned counsel for the appellant submits that the tribunal committed an error in relying upon the testimony of witnesses who were interested in the outcome of the proceedings. It is further argued that no independent witness from the place of accident was examined. According to the appellant, the amount awarded is excessive and requires substantial reduction. On the other hand, learned counsel appearing for the claimants supports the award and submits that proceedings before the claims tribunal are intended to provide just and reasonable compensation. Strict rule applicable to a criminal trial cannot be imported into such proceedings. It is argued that the evidence on record sufficiently establishes the involvement of the offending vehicle and the negligence of its driver. This court has considered the rival submissions and examined the record. The testimony of an eyewitness cannot be discarded merely because the witness is acquainted with the deceased, unless material contradictions or circumstances affecting credibility are demonstrated. Such evidence remains admissible and may form the basis of a finding. In the present matter, the version given by the eyewitness is substantially supported by the police record and medical documents. As regards the objection concerning the driving license, The insurer was required to establish a conscious and fundamental breach of the policy conditions. Mere absence of a particular document from the record does not automatically absolve the insurer to its statutory liability. The evidence produced before the tribunal does not establish that the owner knowingly permitted an unauthorized person to drive the vehicle. The compensation awarded by the tribunal has also been examined. Assessment of compensation cannot be upon speculation, nor should it result in an unreasonable financial advantage. At the same time, the amount must reasonably reflect the economic loss suffered by the dependents. The principles relating to deduction for personal expenses, future prospects, and application of the appropriate multiplier have been correctly applied in the present case. For the reasons stated above, this court finds no substantial error in the findings recorded by the tribunal. The compensation award is fair and reasonable considering the circumstances of the case. Consequently, the appeal is dismissed. The insurance company is directed to deposit the remaining amount of compensation together with applicable interest before the tribunal within 6 weeks from today. Upon deposit, the small shall be released to the claimants in accordance with the terms of the award, subject to verification and completion of necessary formalities. There shall be no order as to costs. Stop.